Welcome to meeting number 5 of the House of Commons Standing Committee on Citizenship and Immigration. Pursuant to the order of reference of Monday, September 22nd, the committee is commencing its study of Bill C-3, an act to amend the Citizenship Act 2025. We have the Honourable Lena Diab, Minister of Citizenship and Immigration, as well as senior officials with us for the first hour to answer questions. And we have 3 witnesses on the second panel, one from the Bloc Québécois, one from the Conservatives, and one from the Liberals during our last hour. Now, the Minister is very popular. You've all indicated that you have questions for her, and because we only have 1 hour, I will be very strict with time. I have brought aids with me today. I have 2 cards. Yellow means wrap up in 15 seconds. Red means your time is up and your microphone will be turned off. As always, kindly wait until I recognize you by name before speaking. I will remind everyone to kindly not speak over each other, as it will be hard for our translators to translate, and it makes their jobs very difficult. Thank you, Monsieur Brunet-Duceppe, for always reminding us of this. Of course, please ensure that all your comments are addressed through the chair. And members, I know you know this, but it's always good to reiterate, please raise your hand if you wish to speak. The clerk and I will manage the speaking order as best as we can. Thank you in advance for your cooperation. And now I would like to welcome our witnesses for the first panel of today's meeting. We have the Honourable Lena Metlej Diab, Minister of Immigration, Refugees and Citizenship. We have also senior officials, including Catherine Scott, Assistant Deputy Minister, Settlement and Citizens. We have Uyen Hong, Director General, Citizenship Branch, and we have Erica Schneiderate, Council Legal Services. Welcome, senior officials. Welcome, Minister Diab. I now invite you to make an opening statement of up to 5 minutes, after which we will proceed with a round of questions.
Madame la Présidente, membres du comité.
Madam Chair, members of the committee, good afternoon, and thank you for inviting me here this afternoon.
Questions for the first hour on Bill C-3. Bill C-3 faces a firm deadline. The court has struck the first generation limit as it existed as unconstitutional in December 2023. Since then, IRCC has was granted multiple extensions to allow Parliament to pass remedial legislation. The deadline we're working with is November 20th. I want to stress that unless Parliament passes legislation, citizenship by descent will have no limit for many, and some lost Canadians will remain in limbo. So to prevent that, we've put forward a responsible, controlled measure in C-3. Le projet de loi a 2 objectifs principaux.
The bill has 2 main objectives. It gives citizenship to people who are affected by the first generation limit, including lost Canadians, and gives a fair access to citizenship by descent in future.
Hard cap based on the first generation is unconstitutional. With that in mind, this bill is a reasonable response. Under C-3, in future cases where a Canadian parent was born or adopted abroad, their child born or adopted abroad will be able to access citizenship as long as the parent has a substantial connection to Canada. Si le parent a passé au moins 3 ans au Canada,
if the parent has spent at least 3 years in Canada before the child's birth or adoption, their child will be a citizen, Canadian citizen, or have access to the direct grant of citizenship for adoptions.
It is similar to the 1,095-day physical presence requirement for naturalization. It also avoids creating new lost Canadians. If we required those days to be consecutive or squeezed into fixed window, we would shut out people who have already spent more than 3 years here, but over several periods, like children who move abroad with their parents every couple of years. This is a technical discussion, and I have department officials with me to speak to specific details if those questions arise. Key parts of the existing legislation have been found unconstitutional. It's our responsibility to define the boundaries of the right to citizenship conferred by Bill C-3, to put clear parameters on how it is to be applied. We've heard concerns that Bill C-3 could mean hundreds of thousands of new citizens which would put pressure on social services. What we know is that between January 2024 and July 2025, we received just over 4,200 applications for discretionary grants of citizenship under the interim measure for those affected by the first generation limit. Previous amendments in 2009 and 2015 saw around 20,000 people apply for proof of citizenship, with fewer than 2,400 applications in the busiest year. Based on that evidence, we anticipate volumes in the tens of thousands over time, and we do not expect any surge. Net fiscal impacts are expected to be limited. Some in this cohort are already here in Canada contributing to general revenues, and those abroad are generally not eligible for most Canadian social programs. Here, it's important to note that each program or service, whether it's federal or provincial, has its own eligibility criteria, which in addition to citizenship would include age, income level, legal status of Canada, tax filing, residency in Canada or a specific province or territory for a specific period of time. Nous avons également entendu des suggestions selon lesquelles le projet de loi.
We have also heard suggestions that the bill should impose security checks on people who become recognized as Canadian under Bill C-3. A cohort, I should note, are largely low-risk children.
Never required security or criminality screening, and Bill C-3 is consistent with the 2009 and the 2015 amendments. So Bill C-3 reflects both the value of Canadian citizenship and the reality of how Canadian families live today, and I welcome the committee's questions. Merci beaucoup.
Thank you, Minister Diab, for your remarks. We will now begin with the first round of questions. We start with Ms. Rempel-Garner for 6 minutes.
Thank you, Chair. Minister, we have a chain migration bill in front of us today at a time when your department's been issuing record numbers of all sorts of temporary foreign visas. We have a housing, jobs and housing, healthcare crisis. So the Parliamentary Budget Officer has estimated that at least 115,000 people would become Canadian citizens under this bill, this chain migration bill. Where are they going to live?
Thank you very much for the question. This is what we know on volumes. From January 2024 to July 2025, the end of that, those were when the interim measures were implemented by the department. The department received over 4,200 applications from those individuals.
Thank you, Chair. So there's a lot of people that you are allowing in this chain migration bill. No, this is my time. Where are they going to live?
Point of order. I'm sorry. I will stop the clock, Ms. Rempel-Garner. Yes, point of order.
It is a point of order, Chair, because we didn't hear the full answer. The member had the chance to complete her question. We need to hear the answer from the minister in order to have
that point of order.
It is my time.
It is my time.
It is your time, Ms. Rempel-Garner, but please allow the witness to finish, to complete their sentences.
I gave her equal time, which you should have been looking at. Thank you, Chair.
We don't have an agreement on equal time, so please allow the witness.
Are you silencing me?
I'm not. I'm going to ask you to continue, but kindly let her to answer the questions.
I would advise not trying to silence me. Where are they going to live, Minister? All the people that you're letting in on this chain migration bill, where are they going to live? CMHC says housing starts are down by 16%. So where are you putting 115,000 auto-liberal Canadians?
Thank you, Madam Chair. Just want to remind the members that this bill was struck down in December 2023. We are here to remedy a situation, and if we do not act, then we are in jeopardy.
Thank you. On that point, why didn't you appeal the court ruling? You didn't. You just let it go.
So again, Madam Chair, we're here today to talk on this bill that is in front of us. It is an important legislation that strikes a balance to protect Canadian values as well as Canadian families.
On this bill, you just said, though, that the bill is here because of a court ruling. The court didn't write this legislation. So I'll ask you again, where are these people going to live that you are putting in this bill that the courts didn't write, that you didn't appeal a ruling on?
So thank you again, Madam Chair. The IRCCs, they saw no surge in the interim measures, nor did they see any surge happening in 2009 and 2015 when similar legislation was in place. I also remind the member that a lot of these individuals are infants, and there's a lot of individuals that are already in Canada paying taxes
just like
as well.
IRCC didn't see the surge in like 1.5 million people, that we didn't have a place for them to live. Who's going to be their family doctor in this chain migration bill? How are these people going to get family doctors? Where?
So thank you, Madam Chair. I remind members again, without this legislation, we need to pass it to protect the value of citizenship in this country, and without it, there will be no limit on citizenship by descent for many people born to Canadian citizens abroad.
And to be clear, that's because your government didn't appeal a court ruling. They didn't use any of the tools in their toolkit. They just said, yay, chain migration. Here is a chain migration bill. So I'll just give you one more shot here. Where are how long are Canadian families going to have to wait in ER rooms because of this chain migration bill?
So, Madam Chair, Bill C3 is a reasonable legislation that finds a limit for the first generation limit. We are required by law, by Constitution, to have proper registration in front of us, and that is why we're here today.
Yes, but you chose not to appeal a court ruling and then table a chain migration bill. That is your government's decision. So you can't answer where they're going to live. You can't answer how they're going to get a family doctor when many Canadians don't have a family doctor. Where are they going to work during the youth jobs crisis? Are they going to sit on EI benefits while you continue to issue TFW permits to Tim Hortons?
So again, as I said in my remarks, Madam Chair, there are rules in place in every province and every jurisdiction in this country, whether it's provincial and federal, in terms of who's entitled to receive what. There's age requirements, there's the requirements for paying taxes, there's so on. That is not something that, as the member suggests, there will be no surge of that happening.
But immigration levels, so you've tabled a chain migration bill. There's at least 115,000 people per the parliamentary budget officer.
Madam Chair.
Point of order, I'll stop the time. Yes, point of
I'm
order.
not sure what chain migration bill she's talking about. I thought we were studying C3, which is actually about
This is debate,
citizenship.
Chair, and it's a Liberal attempt to silence
Not a
me
point of order,
because
Mr.
of their
Zuberi.
terrible immigration policy.
But thank you.
I'm just not
Please,
sure what
we will
she's talking
restart the
about,
time.
what colleague's talking about.
Chair, these Liberals, they really want to silence me because of their chain migration bill. So the minister can't answer where these people are going to live. They can't answer where they're going to get a job, and she can't answer how they're going to get a family doctor. So again, I'm just going to ask, why didn't you appeal the court ruling? I think it's because the Liberals like out-of-control immigration levels. Honestly, and also the other thing is there's no language requirements in this bill. Do you not respect the right for Canadians to at least know one of Canada's official languages?
So, Madam Chair, as I said, this bill has limits on automatic citizenship by descent. Without passing any legislation, there will be no limits. And I don't believe that is what the members are looking for.
There is no limit under this chain migration bill. You are correct. There's no language requirements, no security requirements, no nothing. And the minister can't tell us. So I'm just going to ask one more time. Where are people going to live under this chain migration bill? Who is going to be their family doctor? And where are they going to work in a youth job crisis?
So thank you again, Madam Chair. I want to remind members that a lot of the people that will be caught under this legislation will be minors.
15 seconds.
And
We have a
it
youth
would be
job
also
crisis,
individuals that are already in Canada that are already contributing to our
Where are they going to live?
system as well.
There's 115,000
The ones that are
people at
in
least.
Canada already would have
But the
places
rest of
that
them,
are living.
where are they going to live?
Thank you, Ms. Rempel-Gardner. That is your 6 minutes. We now go to Mr. Fragiscatos for 6 minutes.
Thank you, Madam Chair. Thank you, Minister and officials, for being here. We just heard the phrase chain migration repeated here at the committee. This despite the fact that this is a clear effort on the part of the government to reform the Citizenship Act. And so there's a distinction that needs to be made there, I'm afraid. Minister, in your comments, and you weren't able to get this entirely on the record, but I think one important rebuttal to this particular argument about chain migration does relate to numbers. You gave a number of 4,000 plus there. in terms of what the government has seen up to this point from those that would be affected by this legislation. Can you repeat that fact for us?
Certainly. So, and this is what we know in terms of volumes for the members of the committee and everyone that is listening. During the interim measures, as we know, the bill was struck down in December 2023. The interim measures between January 2024 until the end of July 2025, IRCC received just over 4,200 applications from individuals impacted by the first generation limit who are eligible to be offered consideration for a discretionary grant of citizenship. That includes, one, those born after 2009, when the first generation limit came into effect, so clearly those are children and infants. Two, the descendants of lost Canadians, in other words, the children of lost Canadians who were remedied in 2009 and in 2015, and another section of lost Canadians. So there has been no surge of applications during the interim measures, and similarly, when the legislative changes were implemented back in 2009 under a Conservative government, and 2015 under a Liberal government 10 years ago, which restored citizenship to most lost Canadians, we didn't see a surge of application. Overall, since 2009, there was a little over 20,000 individuals who came forward to seek proof of citizenship. So at the highest point, the department received fewer than 2,400 applications per year. In fact, what we know based on experience is, with those that previous legislation that addressed lost Canadians, as well as those impacted by the first generation limit who did come forward since January 2024, we expect tens of thousands and not hundreds of thousands to be impacted by Bill C-3. And most people, or many people, may not even apply, may not even come forward. So, IRCC is prepared to process those applications with proof of citizenship. And this is the right thing to do. It's something that needs to be remedied. It was found unconstitutional. That's why we're here today, is to remedy that.
Thank you very much. I'm going to turn to officials now, if I could. Again, this does relate to rebutting this point about chain migration and Bill C-3. Can you talk to us, and whoever wishes to take it, on the fact that the bill embraces a cumulative approach of 1,095 days as opposed to a consecutive approach? Touch on that and compare that to, for example, the 1,095 days is, as we know, 3 years. How that compares to permanent residency requirements. Is that consecutive days with respect to permanent residency or cumulative? Just interested in terms of consistency to see if C-3 aligns with requirements for permanent residency in Canadian law.
Sure, thank you. So in terms of the substantial connection test in the legislation, it is demonstrated by presence in Canada for 1,095 cumulative days, as you pointed out. And this is similar to the physical presence requirement that any applicants for citizenship by naturalization have to demonstrate. C-3 uses cumulative presence rather than consecutive, because it recognizes that people demonstrate their connection to Canada in different ways and reflects the way that Canadian families live today. And so would allow a family to demonstrate their connection to Canada, for example, if that individual did their university studies in Canada or came over many summers to spend time with their grandparents. So it gives that flexibility to families, or families where working for a multinational corporation and they're transferred multiple times. So it gives that flexibility to meet that 1,095-day requirement and demonstrate that connection to Canada.
Thank you very much. And I think I have just about a minute left, Chair. So with that, I think it's important to put the the matter into context as well, I wanted to ask those substantive questions on specifics of the bill and deal with this argument again of chain migration, which I think you've done. But the ruling from the Ontario Superior Court of Justice is very clear as it relates to the Charter. What were the specific Charter concerns raised by the court? And again, that's to officials.
Maybe we can go to legal.
15 seconds.
Thank you for the question. I'll just say quickly then that the court's findings were based on Section 6 of the Charter, which are the mobility rights under the Charter, as well as Section 15, so equality rights. And I think I probably don't have time to go into more than that. Thank you.
Thank you, Mr. Fragiscatos. Monsieur Brunel-Duceppe, c'est à vous 6 minutes.
You have 6 minutes. Thank you, Madam Chair. Madam Minister, welcome to the committee and thank you for being here. Before my colleague, Mr. Fragiscatos' question, there was a question about comparing the 1,095 days for a permanent resident and the requirement in the law to become naturalized. Is there a difference? No, it's the same comparison. Because I thought that in the act to become a naturalized Canadian, when you're a permanent resident, you have to stay 1,095 days, but over 5 years. So there is a difference, Madam Minister. Yes, that's true. It's 1,095 days over 5 years. In C3, is it over a period of 5 years? No. So in 30 seconds, I got 2 different answers to a very simple question. Thank you, Madam Minister. So we're using the 1,095 days, but we are eliminating the 5-year limit for that, correct? Yes. Okay, so when S245 was studied here, there was a document that was tabled that said it was very difficult to really verify the 1,095 days of presence in Canada. What kind of justification will the department be asking for to make sure that that requirement has been met? It's a good question. I only have good questions. I will ask my officials to answer. We have already put in interim measures, and so it could be a certain number of documents, for example, proof of registration at a university, tax return, documents like a Hydro-Quebec bill, a passport. Different types of documents would be studied. Thank you. Madam Minister, does Canada collect data on when a person leaves Canada? No, I don't think so. But we're looking to work on that. But my question is simple. One moment, please.
Okay. Oui, le Canada. Oui.
Yes, Canada does. Canada does collect data on when people leave Canada? Yes. That's news to me. So when somebody leaves Canada, the Canadian government is aware that that person has left the country?
We do have a program called Entry-Exit. It is outside my remit, so I don't want to go into the details in terms of how it is implemented, but there are mechanisms in place in order to know when an individual is leaving a country.
OK. Je croyais que le Canada...
I see. I thought Canada did not collect that data. So if I went to the U.S., then people would be aware that I had left the country, but they wouldn't necessarily know when I came back. Okay, I'll go check that. Thank you. Now, let's talk about the figures. I'd like a bit of clarification. The Bloc has always been positive about lost Canadian legislation, but we need to clarify certain points. Some people have been raising 4 million people in the Canadian diaspora. Other people talk about 1 million people. The parliamentary budget officer talked about 150 to 150,000 people. So what are the department's figures? Because if we're going to put in place legislation that provides citizenship for people, we need to know what the real figures are. I can imagine that the department is able to tell us how many people will be affected by this law. Thank you for the question, Madam Chair. So this is what we know. Forgive me, Madam Minister, I just want a figure. You must know how many people will be affected by this. Okay, it's impossible to know exactly the figure. Okay, so it's impossible to know how many people will be affected. So, Madam Minister, you said there are people who are already in Canada who would benefit from C3. And so the housing crisis won't be worsened by this. I can imagine that you must have some figures about that. You must have data on how many people are already in Canada who will be affected by C3. Well, we have before us a bill. We have to enact a law. We are limited by the courts. But normally, you should know how many people will be affected. The individuals must show a substantial link with Canada. Thank you, Mr. Brunel-Duceppe.
Round. And now we begin our second round with Mr. Redkop for 5 minutes.
Thank you, Madam Chair, and thank you, Minister. Minister, in May of 22, you said the following: fostering bilingualism is a personal priority for me. I think we can make inroads on this problem by by working hard to increase Francophone immigration. So obviously language is important to you, and it's important to me also, and that's why I'm concerned that there is no language requirement for the new citizens that will be created by C3. So can you assure Canadians that people getting citizenship through this pathway will be able to speak either French or English?
Chair, of course, language is very important to me, and what is also very important is having Canada's both official languages here, obviously in Parliament, but across the country. This is citizenship by right. It is a right that we are restoring to people. Again, a number of those people will be infants and children, and my hope is they would be speaking both of Canada's official languages and perhaps a third, fourth language as well.
Okay, I would just point out, though, that the courts are not the ones that are making this bill. This is your bill. You're creating this bill, and you are the one that's creating the mechanisms by which to become Canadian. So you have the option to put language into this bill, and you're right, if children are doing it, that's fine, they don't have to do it. But what about older people that come? So that's what concerns me about this, is that there's no thought in this to getting language in here. And the other thing that I'm concerned about is that there's no requirement to take a citizenship test. So are you confident that these new Canadians you're proposing to create will understand Canadian values? And how is that fair if they aren't?
So Canadian values, that's exactly why this bill is in front of us, is to protect those Canadian values, is to ensure that people who want to be Canadians because they value being a Canadian are allowed to be Canadian. It's to give back and to restore that right to many that have lost it. There's also the substantial connection test that is extremely important. We are here to right a wrong, and that is exactly why we're
Minister,
here today.
what are the Canadian values?
What are the Canadian values? Obviously, one of them is protecting our our official languages in this country. It is, for helping each other. I mean, our Canadian values are human values.
If it's protecting Canadian our languages, why is that not in the bill? I'm surprised by that. But I'm also concerned about another thing, and that is that there is no security check of any kind in this pathway. So we know that in every pathway to citizenship, a certain percentage of people fail our security checks and then are denied citizenship because of that. And your transition binder specifically talked about increasing scrutiny resulting in higher refusal rates. So some of these people will for sure have security problems and even criminal records. And admitting safe and secure people is paramount to Canadians. So are you okay that this law will grant citizenship to people with criminal records?
So this law will give citizenship to people who have lost it or people who should have had it anyway. If it's the same bill that was introduced in 2009, 2015 as well, with regards to that. So
to be clear, though, you're saying that it's okay.
And many of them are children.
It's okay to allow people to have citizenship if they have criminal records. We're not going to check that.
So again,
point of order.
Yes, I'll stop the clock. Point of order.
This bill deals with people who are not yet born. How can an unborn person have a criminal record?
That's not a point of order. I'm sorry.
Yeah, point of order, actually, on this Liberal who keeps interrupting us and trying to silence us. He knows better. I was told he's been an MP for 10 years or something. He knows better than to interject with debate during my colleague's time on inanities.
Thank you, Ms. Rempel-Gardner. Mr. Redekop, will restart the time. Thank you.
So if we do have children, that's fine. They should easily pass the security test. But what about those who are older? And so are you saying that people that have violent criminal past or terrorism-related backgrounds are just going to be given citizenship through this pathway?
Again, I want to go back to the reason for this legislation. It's because it was struck down as constitutional. The limits that were in it were against the Charter. We are here and we are putting limits on Canadian citizenship. We are trying to create a balance. People have to establish a connection, substantial connection to Canada with the number of days, but also proof of that. And again,
Minister,
we are here to right a wrong, and it is a right to a lot of people to have citizenship.
So, Minister, the courts did not tell you how to do this. They said you needed to do something, but the method that you're choosing to do, that is of your own choosing, and you are choosing to not put security in here. You also seem pretty confident that there's a lot of children in this. So does that mean you have numbers to prove that how many of these will be children versus adults?
Well, if you do the math, I mean, based on the years that we are using, the department has done the math, and a lot of them would have been born prior
15 seconds.
After 2009.
One last quick question. Can you assure Canadians that no terrorists will become citizens through this legislation?
Again, these are people who are already citizens. Have it not been for
Thank you, Minister. Thank you,
right
Mr. Redekop. Thank you. We now go to our next questioner, who will be Mr. Samir Zuberi. 5 minutes.
Thank you, Madam Chair, and thank you to witnesses for being here. I want to ask about a hypothetical situation, which I don't know is encompassed in this act. We're dealing with I want to give a scenario that everybody can understand. Somebody chooses to have their career outside of Canada. They have their family and children born outside the country. This child later on has their own family and comes to Canada. And lives here. If they come to Canada with a minor child, let's say 4 years old, they cannot pass on the citizenship to their 4-year-old child. It can only pass it on to future-born children. What happens to the 4-year-old, and how do they actually become a citizen?
Thank you for that question, Mr. Zubiri. I'm going to have the official answer that specific scenario for you.
Thank you for the question. There are two parts to the bill. One is if the child is already born versus in the future if the child is yet to be born. So if the child is already born and to a Canadian parent beyond the first generation, they would automatically become citizen by operation of law. But in the future, on or after when the bill comes into force, and so we're talking about a child that's yet to be born, as long as the Canadian parent can demonstrate a connection of 1,095 days, that parent can pass on citizenship to the child beyond the first generation.
Thank you. In terms of how did you come to the number of 1,095, and what's the rationale for that?
So 1,095 days, as we mentioned, is reflective of the requirements that are also set for naturalized Canadians. So also have to meet the 1,095 days to obtain citizenship.
So in terms of the issue of lost Canadians, do you see that this bill will remedy in whole the concern of lost Canadians and respond to the court's requirement?
So yes, that is why the bill is drafted. It has a number of objectives, one of which would be to remedy citizenship status for those who were affected by the 2009 law, and then would establish a revised framework for citizenship of descent going forward, as you were just explaining. And obviously there's a comparable treatment for adopted children as well. Lastly, it does clarify some citizenship legislation. Maybe not everybody wants to be a Canadian, and so it also gives the process where you can renunciate if there's a renunciation process. But it also makes it clear, and it clarifies for everyone exactly what the rules are if you wish to pursue those.
Thank you. And how will you determine the 1,095 days have been lapsed or satisfied?
So I think I'll just try and do the best that I can here, because I think Monsieur Brunel Duceppe asked the same question, and that is, officials will take a look at, I guess, if they've lived in Canada, if there's mortgages, mortgages won't do it, but leases, documentation, entry, exit out of Canada, if they spent summer in cottages. In Nova Scotia, we have lots of cottages. People come in the summertime quite a bit and bring their children. There's many facets that one can look into that, but of course, I hope we would have officials taking a look at that. I would suspect it might be kind of similar to when you look at the 1,095 days before you get your citizenship if you're already in Canada after you've been a permanent resident. Might be some similarities there as well, but
15
sure there will be a
seconds.
lot of difference given that some people may be abroad as well.
Thank you. Oh, that ends that round. Thank you very much, Mr. Zuberi. Monsieur Brunel Duceppe, c'est à vous 2 minutes et demie.
You have 2.5 minutes, Mr. Brunel Duceppe. Thank you, Madam Chair. I'd like to come back to the program you mentioned that looks at exits from the country. If I understand correctly, was put in place in 2019-2020. That's what I found on the internet.
Responsible for, so it would be inappropriate for me to speak to the
Parfait.
details
Mais
of
ce qu'on me dit, c'est que c'est depuis 2019.
Perfect, but I understand it's from 2019. So if I understand correctly, before that date, Canada did not look at when people left the country. So, Madam Minister, before 2019, people who are affected by this bill, it'll be hard to show that they actually spent 1,095 days because before 2019, their exits from Canada were not recorded. So I'd encourage you to look at that. Countries like Denmark, Portugal, Spain, and Sweden included in their respective laws language requirements for citizenship by descent. You understand how important language is in Quebec. Do you think that Spain, Denmark, Sweden, etc., are on the wrong path when they require that people need to learn the official languages of those countries to become a citizen by descent? Thank you for the question. Language is very important. I completely agree with you. But in this case, we're dealing with Canadians who are born as citizens by descent. The same as people who are born in Canada. And for that reason, there's also a jurisdictional scan that we did with lots of other countries, and if you'd like, I can ask the officials to speak to this. No, that's fine. Your answer is acceptable to me, Madam Minister. Since I'm from the bloc, we have less time. Thank you, Madam Minister. I don't have enough time left to ask another question. Thank you, Mr. Brunel-Duceppe.
Rempel Garner for 5 minutes.
Minister, how many people exited Canada last year?
So thank you, Madam Chair. Again, we are here today to talk about Bill C-3. It's a bill that many Canadians and many families have been waiting for many, many years.
The reason why I ask this is just to pick up on the last stream. How are you going to prove a claim that's made under this chain migration bill if it's prior to 2019 if you can't track entry and exit data? Like, don't you think that there's a pretty big potential for fraud there?
So thank you, Madam Chair. Again, the current legislation that that was struck down was found to be not acceptable. There's a lot of consequences to Canadian families that are living.
So I get your word salad, but so let's say somebody makes a claim before that their 5 years happened before 2019, and you're not tracking exit and entry data. Like, could anybody just be like, yeah, like you said, I went to the cottage, please give me citizenship, like a Costco card. Or can you tell me how fraud wouldn't happen here?
So thank you, Madam Chair. Again, like-minded countries, the M5s, all have policies that limit the passing of automatic citizenship by descent. Canada. We believe we've struck a balance here by putting a substantial connection to the country.
What's the balance? Like, if somebody's coming in prior to 2019 and you can't prove if they entered or exited, then like literally anybody could just be like, yeah, I'm Canadian, give me citizenship. This is not sus at all. Like, do you understand what you're saying here? You've introduced a chain migration bill, and you can't prove if somebody came or entered the country. Like, do you realize how ridiculous that is?
So, Madam Chair, again, I think the question is a bit ridiculous, to be quite frank.
Thank you. I will be clipping that.
Point of order.
People need to demonstrate that they have the substantial connection.
Yes, Ms.
I think
Zaid.
opportunity should be provided to the witnesses to answer the questions, and I think this is not the decorum we should have in this committee. There needs to be a question, and then there needs to be an answer.
Thank you, Ms. Said. Thank you. We'll allow the witness to answer the question. We will restart the time. Ms.
Actually, just point of order on that with the time stop. I would love an answer. It would be awesome. I actually agree with my colleague. I'm not getting an answer from the minister. Thank you for this point of order and raising it. I'm asking, Madam Chair, how she's going to prevent fraud on this. And you started my time. I'm making a point of order, right? So
yes, you're asking a question.
I didn't get an answer.
So I'm going to restart your clock, and then we will have the minister respond.
Thank you.
Minister Diab.
So can I just restate the question, because my colleagues were trying to silence me? So
yes.
for people who are listening, the Liberals have tabled a chain migration bill, okay? And in order to fulfill the requirements of this chain migration bill, which will give them Canadian citizenship, they have to say that they were in Canada for 3 years. But prior to 2019, or we don't even know today, the Liberals can't prove if they were in Canada. So, Minister, how are you going to prove rampant fraud and the abuse of Canadian citizenship?
So thank you for that. We already do this for all naturalized Canadians. Applicants will be asked to submit evidence of their Canadian parents' physical presence. I mean, this is something that's been done in this country and in all countries with proof on the citizenship application.
Okay,
so
but
it would
again,
include things like pay
I'll stop the
stubs,
clock, but
educational
hold on.
records.
I'll stop the clock, Minister. Ms. Rempel-Garner, please allow the witness to finish.
I don't have to, Chair. On a point of order, I do not have to let the Liberals word salad my answers when I'm asking about the value of Canadian citizenship. Sorry, you can't do that.
Here is the problem, Ms. Rempel-Garner. There is crosstalk, and it is very hard for interpreters to interpret, and it's very difficult for them to do their jobs. Kindly allow, if we could have one person at a time. Ms. Minister.
No, it's me. I get to ask the question again since you interrupted me again.
And then I will allow the witness to answer the question. Thank you.
Point of order. So if the witnesses answer direct questions, then we wouldn't get into these kind of situations. But if we're allowed the witnesses to continue off.
Mr. Ma, this is not a point of order. Okay, Ms. Michelle Rempel-Garner, please go ahead.
Thank you. So, Chair, since we're not going to get an answer on, obviously the Liberals have written a chain migration bill that's going to allow for rampant fraud. The minister doesn't include a requirement for taking a citizenship test in this chain migration bill. She said that this bill is the right thing to do. Is it right to grant Canadian citizenship to somebody without taking a citizenship test?
So, Madam Chair, as I was saying, officers will assess the totality of the information that's presented when an application in front of them and determine whether or not they're satisfied and whether or not the individual should be given.
But there's no citizenship test. So are you saying it's the right thing to do to give Canadian citizenship to somebody who can't speak one of Canada's official languages and doesn't have to take a citizenship test with no security screening? Is that what you are telling this committee that we are supposed to vote for with this chain migration bill?
Madam Chair, this bill was drafted to have reasonable limits that would surpass the constitutional rights of people. It strikes a balance by protecting the value of Canadian citizenship. Gives fairness to Canadian families.
Wouldn't you argue that
Ms. Rempel-Garner, please allow the witness to answer the question.
She is word salading.
Please let her finish the question.
Okay. Minister, yes or no, do you think it's right to give Canadian citizenship to somebody without them having to take a citizenship test?
This bill is here to protect Canadian values, and I believe we've struck a balance. If you have any amendments, we are, the committee's happy to look at those.
So you'd support an amendment to make somebody take a citizenship test?
I said if there's amendments, that's why the committee is here. So what I'm saying is this bill protects the value of citizenship, and it is something that is very important to all Canadians.
Ms. Rempel-Garner, please allow her to answer.
Would you accept an amendment to make people take a citizenship test via this bill? Yes or no?
It's not up to me to accept or reject. This is the committee's findings. I was on a committee
Why didn't you draft it with a citizenship test?
So again, we've done jurisdictional scan, and officials are here to talk. Happy to give you what many other countries around the globe have in reference to this.
Thank you, Minister. Thank you, Ms. Rempel-Garner. We go to our next questioner, which is Ms. Amandeep Sodhi for 5 minutes.
Thank you, Minister, for being here today. My question is to you, Minister. Can you please elaborate on how Bill C-3 specifically addresses Canadian citizenship issues rather than immigration policy?
So what we have here is the current first-generation limit to citizenship no longer reflects how Canadian families live today and the values that define our country. So the government introduced Bill C-3 to extend citizenship by descent in a way that balances fair access and protects the value of Canadian citizenship. We believe in this bill that we have struck a balance, that we have put reasonable limits on automatic on citizenship. And going forward, Bill C-3 would allow the child of a Canadian parent born abroad, parent born or adopted abroad, actually, with substantial connection to Canada to acquire citizenship if the child is born abroad and would have access the direct grant of citizenship if the child is also adopted abroad. So the bill addresses, again, the lost standing issue of the term that we've heard, lost Canadians, those who have lost or never acquired citizenship under former citizenship laws, and it restores citizenship to the remaining lost Canadians and provides access to citizenship for their descendants.
Okay.
If you would like a little bit more, that's why officials are with me today for the first hour as well.
Okay, perfect. And once again, to reiterate the urgency of passing this legislation, could either one of you please let the committee know what the consequences are for Canadians if Bill C-3 is not passed before the deadline?
Question. I mean, the reason that we are here is that we are under a limit. As I said, December 19, 2023, the court declared that parts of the bill were unconstitutional. As a result, the department had special measures from January 2024 forward, with the expectation of a certain bill that would be implemented. So, we are here today with the legislation. We believe that we've put a substantial connection test in there of 1,095 days to provide clarity to people and families, and as well, protecting the value of Canadian citizenship and ensuring that those that have been waiting for years, have the citizenship that they are looking for and have been waiting for.
And Minister, why do you think it's important to limit citizenship by descent?
So again, that's why we've put a limit of 1,095. We believe it's important for people to show that there is a connection to Canada. Again, officers will assess that connections as they do every day, as they've been doing every day in every single file that happens. And we believe it's a reasonable limit, but it also there to protect the value of our Canadian citizenship.
Okay. And how does Bill C-3 impact who is recognized as a Canadian citizen as opposed to who is allowed to immigrate to Canada?
So immigration to Canada, obviously, people apply to immigrate to Canada. There's many pathways, federal programs, provincial programs, territorial programs. So it's very different. This is giving the right of citizenship to people who have lost it, who should have had it, and dealing with it on a go-forward basis.
And
officials, if you'd like to add anything on that, to clarify anything else, please let me know.
15 seconds.
I think I'm good, Madam Chair. There won't be enough time for another answer.
Thank you so much, Ms. Soti. So, colleagues, we have just over 7 minutes left in this first hour. Can I suggest maybe 2.5 minutes for each of the parties? Is that okay? 2.5 minutes for Mr. Menegakis, 2.5 minutes for Ms. Zaid, and then 2.5 minutes for Monsieur Bruxelles-Duceppe. Yes, perfect. Okay, so we will start with, yes. Oh, Mr. Redekop. Yes. Okay, we will do 2.5 minutes for Mr. Redekop, please.
Thank you, Chair. I know that the courts told you that you had to change this law, but they didn't tell you how to change it. The how part is up to you, Minister, and the government. So my question to you is it reasonable, is it the right thing to do to not include a requirement for people to have one of our two Canadian official languages? Is that the right thing to do, in your opinion, in this bill? And I'm speaking specifically about people who are going to be over the age of 18 that will be affected by this bill.
So thank you for that question.
It's a quick answer is all we need.
Thank you for that question. Madam Chair, as I said, the purpose for the bill is to return citizenship to people who have lost it and should have had it already.
Madam Chair, okay, I'm just looking for a yes or no
Canadians who are
answer.
born citizens by descent are not required to demonstrate official language capacity.
Okay, and you believe that's reasonable. And do you think the same thing is true about those same citizens who are, or those same people who are over the age of 18 should get citizenship without a citizenship test? Just a yes or a no.
Well, citizens who are eligible, do not right now get citizenship tests. I wish they did. We should have civic classes.
Are you saying that people that are applying for citizenship do not have to do a citizenship test? Is that what you just said?
No. I'm saying Canadians. Canadians do not need to have.
So I'm saying people applying for citizenship through this pathway who are over the age of 18, do you think it's reasonable that they should not have to do a citizenship test?
So again, the answer, to be clear, Canadians who are born citizens by descent are not required.
Okay, so I'm not sure if you fully understand this, but the law that we are debating here, that we're talking about, is going to we have the option to create it however we want. And so we could choose to create it to say that these people have to have tests. So you're saying that you don't want that. That's not something that's important to you as a minister, as a government. The same with the security checks. You're saying that it's not important that if you have a person trying to attain citizenship through this process who's over 18 shouldn't have to do a security check?
So the bill is drafted
15
taking
seconds.
into consideration the Charter, the Constitution, but it's also consistent with the 2009 law as well.
So this is reasonable. So not having security checks, allowing terrorists into the country through this potentially is okay.
So that's exactly what I didn't say.
Thank you, Minister. Thank you, Mr. Redekop. We now go to Ms. Salma Zaid for 2.5 minutes.
Thank you, Chair, and thank you to Minister and all the officials for appearing before this committee on this important legislation about lost Canadians. Minister, today we have heard a lot about the language tests, the citizenship tests, and the Canadian values tests. So could you please explain the difference between the birthright citizenship and citizenship by naturalization, and how birthright citizenship is a right and not a gift?
So you're right. It is a right, and that is exactly why we're here today. It's to make right what has been wrong, and to grant citizenship for people who have the right to have it. And just for a lot of more clarity, why don't I get one of the officials to also comment on that?
Thank you for the question. So Bill C-3 does not include any requirements, as you have pointed out, for individuals who become citizens by descent to pass security or criminality screenings, as well as to pass a language or knowledge test. Because what we're talking about is Canadians who were born Canadian citizens. They are considered to be citizens by descent, and citizens by descent currently do not have to undergo any of these tests. Furthermore, most of those who were excluded from citizenship because of the first generation limit are those born after 2009 when it came into force, which means what you're looking at is a cohort that is largely minors, 16 and under, if this bill comes into force this year. And they are generally deemed lower risk for security and criminality purposes. Citizens born after the bill comes into force, they're essentially newborns or very young children when their parents apply for their proof of citizenship. These babies or young children do not pose a security risk in becoming citizens. Similarly, Canadians who are born citizens by descent are not required to demonstrate their official capacity for knowledge of Canada.
15 seconds.
So on principle, this cohort of citizens by descent should not be subject to such requirements as well. And this is consistent with the changes that we made in 2009 and 2015.
Thank you so much, Ms. Hong. Thank you so much, Ms. Salma Zaid. Pour terminer notre dernier
To finish, to wrap up, our last questions will come from Mr. Alexis Brunel-Duceppe. Thank you, Madam Chair. Madam Minister, there are cuts everywhere. Your Prime Minister asked all of his ministers to cut costs. And here's a bill that will mean that between 250,000 and 1 million people will be filing applications. Do you have the resources to deal with this? And you also talked about the 90 days. Do you have the resources to do this work? You're already in the red when it comes to delays for the other programs in your department, and now you're going to be adding a new program. Have you calculated how many people it'll take, how many people you have to add to your team, and the cost when it comes to the bureaucracy and administration of this program? Thank you, Madam Chair. That's an excellent question. I always have good questions. IRCC is prepared to process these applications with our current capacity. So you're not adding any additional resources at IRCC, even if C3 passes? The department has said that that won't be necessary. So you're not adding any resources, but you might be adding up to 1 million applications that have to be processed within 90 days, and you have the resources that you need within IRCC. That's what I've understood. Yes, but I will let this official answer. Over the last 10 months, we received 4,200 applications. And looking forward, the department has the necessary resources within its citizenship team to process the new applications. And how can you make sure that you can actually have the capacity you need if you don't know how many people will be affected by C3?
The records that they have received.
On dit que ça peut toucher 1 million de personnes.
No, pas million.
Ah, pas de million? Ah, maintenant,
You say that this could affect 1 million people? No, not 1 million. Ah, so now you have a figure? Thank you, Mr. Brunel-Duceppe.
Very quickly. So I want to thank the minister and the officials for their time. Thank you for being here. Thank you for your patience. Thank you for answering all the questions. We are going to suspend for 5 to 10 minutes just so our current witnesses can leave and we can get the second panel set up. Thank you. So we are now in the second hour of our meeting today, and we have a panel of 3 witnesses. And just a reminder to our witnesses, kindly wait until I recognize you by name before speaking, and all comments should be addressed through the chair. So in terms of our witnesses for the second panel, we have as an individual, Michael Bonner, Senior Fellow, Aristotle Foundation for Public Policy. Welcome, Mr. Bonner. We have Mr. Don Chapman, who has written a book on lost Canadians. Welcome, Mr. Chapman. And from the Office of the Parliamentary Budget Officer, we have 3 guests. We have Mr. Jacques, Interim Parliamentary Budget Officer. We have Mr. Elmar Zugi, Senior Analyst, and we have Louis Perrault, Director of Economic Analysis. Up to 5 minutes will be given for opening remarks, after which we will proceed with rounds of questions. Mr. Bonner, we have you up first for 5 minutes.
Madam Chair, honorable members of the committee, thank you for giving me the opportunity.
Citizenship and immigration. It is an honor to be here before you today to discuss our national policy on citizenship. Je vous suis très reconnaissant pour votre temps.
I'm very grateful for your time and commitment to shaping Canada's immigration policies, and I look forward to contributing to this important discussion.
Policy advisor, government relations professional, historian, and a senior fellow at the Aristotle Foundation for Public Policy. Earlier this year, the Aristotle Foundation published a study of mine on Canadian immigration policy. It is called Repairing the Fray, Improving Immigration and Citizenship Policy in Canada. The purpose of that study was twofold: to explain why a long-standing consensus in favor of immigration had broken down over the past 10 years, and to offer some recommendations for improving immigration and citizenship policy, and thereby to restore confidence in our immigration system. One of my main criticisms of recent policy was that Canadian citizenship was not valued highly enough. I made the following comment: we have the right and the obligation to raise the value of Canadian citizenship and to demand more of our citizens. Above all, efforts at integration should proceed not from a dislike of other places, but from a love for Canada. Les Canadiens sont fiers de leur identité.
Canadians are proud of their identity. Over 4 centuries, settlers and immigrants have contributed to the richness of our country, founded on a proud history and a distinctive identity. Canada is a constitutional monarchy, a parliamentary democracy, and a federal state. We, the only constitutional monarchy in North America, have inherited the oldest continuous constitutional tradition in the world. Canadians are united by a shared commitment to the rule of law and the institutions of parliamentary government.
We have welcomed many generations of newcomers eager to assist in the building of our great country. It was, accordingly, a shameful error to describe Canada as a post-national state having no mainstream and lacking a core identity. It was strange to hear this from a Prime Minister, and even stranger, as it seemed to me, to refashion citizenship policy to reflect this supposed void in the heart of our country. The theory that we are a non-nation without culture or norms is absurd, and Canadians rightly rejected it. An easily foreseeable consequence was the breakdown of trust in our immigration system and a rising demand that Canadian culture and institutions be shown greater respect. This has been borne out in recent polling. Nearly 60% of Canadians of all backgrounds now claim that newcomers do not share Canadian values and that they fail to integrate themselves within Canadian society. 51% expect government institutions to do more to integrate newcomers, and 55% believe that immigrants must adopt broad mainstream values and traditions. However we may feel about that, it seems that Canadians have no doubt that there is indeed something to belong to here, and that citizenship is important and valuable. Now, Bill C-3 aims to reform Canada's Citizenship Act. It addresses the first-generation limit on citizenship by descent, which has prevented some Canadians born abroad from passing citizenship to their children born outside the country. The bill responds to a 2023 Ontario Superior Court ruling declaring the first-generation limit unconstitutional, and it seeks to restore citizenship to the so-called lost Canadians. This ruling could have been appealed and perhaps should have been. Nevertheless, there are perhaps some injustices and problems which this bill may correct. But as it stands, I fear that it will do more harm than good. Removing the first-generation limit without a cap on generational descent will extend citizenship to persons with little or no tie to Canada, perhaps indefinitely. This may exacerbate citizenship tourism, whereby people claim the benefits of citizenship, such as healthcare or a passport, without contributing to Canadian society. For a Canadian citizen parent born outside Canada to pass citizenship to his or her children born abroad, Bill C3 requires that the parent must demonstrate, quote, a substantial connection to Canada. These are fine words, but according to the bill, this amounts only to having been present in Canada for a mere 1,095 cumulative days before the child's birth. That is only 3 years, which may be accrued at any point in the parent's
15
life.
seconds, Mr. Bonner. Kindly
Many
wrap up.
Canadians will, I think, rightly wonder whether this really constitutes a substantial connection to our country. And many will expect that the government require more of its citizens. Cela dit, je vous remercie encore une fois de votre
I
attention.
thank you once again for your attention. Madam Chair and honorable members of the committee, I'm available to answer your questions. Thank you, Mr. Bonner.
You are next for 5 minutes.
I'm the head of the Lost Canadians. I coined the term. I lost my citizenship when I was 6 years old because I was born in Canada in wedlock and not adopted. Had any of those factors been different, I would have remained
Point
Canadian.
d'ordre, Madame la Présidente. Je suis vraiment désolé, on n'a pas la traduction. Ah, OK, c'est réglé. Merci.
Okay, we'll start again. Yeah, we'll start
Okay.
again.
I'm the head of the Lost Canadians. I coined the term. I lost my citizenship at age 6 because I was born in Canada in wedlock and not adopted. Had any of those factors been different, I would have remained Canadian. Confused? Well, of course, because the laws were and remain a convoluted mess. It took me 47 years to become Canadian again, as I was forced into becoming an immigrant naturalized citizen. To be clear, C3 is not about immigration. It's the result of a court decision putting fairness in our Citizenship Act, about righting historic wrongs and bringing the act into compliance with the Charter. Saying lost Canadians are immigrants is absurd. It's a citizenship issue, period. To repeat, C3 is not about immigration. C3 fixes the unconstitutionality of the first generation born abroad, and for the first time ever makes the Citizenship Act charter compliant. Women will have equal rights going forward and backward. How ironic that the same gender discrimination was in the Indian Act. Bill S3 fixed that with retroactive effect going back to 1870. Indigenous women could now confer Indian status but not citizenship, which begs, of course, the constitutional question about unequal rights still embedded in the Citizenship Act. C3 corrects that injustice. For reference, because it's applicable, is a second Supreme Court ruling, Respondent Advocate General for Scotland versus Romaine. It means no political party here has a choice. It's a matter of upholding the Charter and the rule of law. Years ago, Canadian women who married Americans were stripped of their citizenship. And hey, what you don't know about citizenship law can come back and hurt you or a loved one. Canada's very adept at making its own people stateless, with victims often being women and children. C3 corrects this as well. Please get past surface reactions about non-mitigating factors like criminal background checks, which for lost Canadians was declared unconstitutional in a 1997 Supreme Court ruling, Benner versus Canada. Look also at the December 2000 CIMM Committee report, which said, and I quote, "Background checks are only appropriate for candidates seeking a grant of citizenship as opposed to those for whom citizenship is a birthright. This implies that lost Canadians should not be subjected to background checks as a precondition for having their citizenship resumed," unquote. Case closed on background checks. That is, unless you wish to go against the unanimous Supreme Court ruling, which then is a violation of the rule of law. Per the court, you don't get to pick and choose. Everyone must be entitled to the same rights, and lost Canadians have a right to citizenship. So you as parliamentarians, it's your job to defend and protect that right. If we must undergo criminal background checks to secure our constitutional right of citizenship, then it must be so for all Canadians. If we must own land or pay taxes, it has to apply to everyone, including newborns. By conflating the issue with immigration, one, MPs don't understand the difference, which is frightening, because being on an airplane, I expect my pilot to know how to fly, and likewise, I expect MPs to know their portfolio. Two, MPs understand but choose to fearmonger and mislead. Just look south to see the deterioration of a country when a major political party goes down that path. Or three, it's a combination of one and two, all scenarios being bad, leaving Canadians, including children, in harm's way. Knowledge should win the day, which is impossible by not embracing it. One political party won't meet with me. My calls go unanswered. When I went to testify years ago, the members controlling the committee went in camera and canceled the meeting. No lost Canadian testified on a bill about lost Canadians. And before I testified on S-230, I was asked not to divulge the accurate numbers. There's a pattern here. Also being given just 5 minutes to testify, well, no wonder we're at 12 lost Canadian bills and counting. Would you get on a plane with a pilot who had just 5 minutes worth of flight instruction? I'm expecting you to do your job and really learn about the issue. Canada, unconstitutionally, denying Canadians of their identity and culture through citizenship and violating the UN Conventions on the rights of the child, the reduction of statelessness, and the elimination of all forms of discrimination against women is unconscionable. The Bloc certainly understands and defends culture and identity. C3 is the best remedy, as is. I'd like to have amendments, but we can't delay. The suffering of fellow Canadians must end. I urge you not to have your name recorded for supporting human rights abuses and unequal rights. Rather, vote for C3. Thank you.
Monsieur Jacques, s'il vous plaît, 5 minutes.
Mr. Jacques, you have 5 minutes. Good day, Madam Chair, Vice Chairs, members of the committee.
Formerly Bill C-71, during the 44th Parliament in December 2024. Based on our analysis, we estimate the total net cost of the proposed amendments to the Citizenship Act to be $20.8 million over 5 years, beginning in the current fiscal year, 2025-2026. The total number of persons that would be affected is estimated to be around 115,000 over the same period. Nous serions heureux de répondre à toutes vos questions concernant.
We would be pleased to respond to any questions you may have regarding our analysis of Bill C3. Thank you, Madam Chair.
That was well short of 5 minutes, so thank you very much. And so now we start our round of questions. Our first round of questions is 6 minutes. 6 minutes. And we are going to begin with Mr. Kostas Menegakis, please, for 6 minutes.
Thank you, Madam Chair, and thank you to our witnesses for appearing before us today. Mr. Bonner, you've written that it's time to totally overhaul Canada's immigration system. You've also written, to put it bluntly, many of the immigrants that we attract and keep shouldn't be here. Could you expand on these statements, given that Bill C-3 allows people who have never been in Canada to become Canadian citizens without taking a citizenship test, without having a knowledge of one of the 2 official languages of the country, or no security checks are required, and what risks you see with this approach?
Thank you. My principal concern is to restore confidence in an immigration system which has served our country very well for rather a long time. Not only to restore confidence, but to restore the former consensus which held good in this country and which is not reflected elsewhere anymore, unfortunately. We should also be wary about taking headlines for things that I've written. That the comment that I was making, some of those things that you refer to, is that it is a question of economic integration, and Canada has been doing a worse and worse job on that score over recent years, and the number of people who take citizenship and then leave the country, I think, speaks for itself. That this is a significant challenge that the country has not been able to address. Now, I'd like to pivot back to what I said originally. The question is about restoring confidence in a system that has been, I think, badly shaken over the past several years. And there are certainly merits, as we have heard, in the concept of restoring citizenship to those from whom it should not have been alienated in the first place. And that is something that merits exactly the kind of examination that's going on here right now. But there are many larger and broader questions pertaining to the integrity of our immigration system and public confidence in it, which this is not going to address. And if we get this wrong, it will only add to the problem.
Well, considering the Liberals already wrecked our once proud immigration system, I agree with a lot of the points you made. We've had 7 immigration ministers over the last 10 years. There appears to be a problem finding a competent minister to run the file. Do you think there would be a capacity to process thousands of new citizenship applications, given the current backlogs and processing times today?
Depending on the number of persons involved, that could be a very serious and certainly a realistic concern. And to judge by past examples, this is a concern that already exists within the system, such as it already is. I don't know if anyone has yet put forward numbers with confidence as to how many people this would affect. I've seen reports in the media of very, some figures go as high as 1 million. Until we know that for certain, I would be very wary.
Do you believe that C3 is missing an opportunity to clearly articulate and test for an understanding of the fundamental democratic values which you advocate for and are expected of all Canadian citizens?
I think that that's something that should be given very serious consideration, and again, it speaks to the general challenge, the general loss of confidence that has taken place in our immigration system, and we should get that right above all.
Thank you, Mr. Bonner. I'd like to shift over to our PBO officials that are here with us. Thank you for joining us. Bill C3 is a cut and paste bill. A minister was elected on April 28th. Within a number of days, possibly a week or two, she was appointed a minister. Just a couple of days after that, she changed the title of the bill, C71 to C3. Have you seen any change? Have you done an update on the numbers that you have provided us? It's still about 115,000 people that are going to be affected.
Thanks. So we've looked at the legislation, and it seems to be substantially the same as the previous bill that we costed for the previous Parliament, and that cost estimate was prepared in December. I noticed that during the minister's earlier testimony, there was a reference to updated numbers with respect to 4,200 claims coming in. We haven't seen those data, so potentially we could circle back and update it. I would say that, substantially, we wouldn't be here at committee today if we weren't confident in the numbers that are currently on the website.
I tend to believe your number.
Yeah. If it wasn't useful for parliamentarians, we'd take it down.
Have you done any estimates on how much these new Canadian citizens by descent would cost taxpayers in extra social and healthcare costs?
No, we have not. The cost estimate is squarely focused around the cost of applications and processing.
Okay, so it's about 115,000 people. We don't know what the impact this is going to have from a cost perspective. Have you done any estimates on what it would, how this would impact the job crisis that we're currently facing in Canada?
Not specifically with respect to this legislation. If it is the will and the interest of the committee, obviously the committee can pass a motion, and we'd be happy to go back and prepare additional estimates on this.
Thank you, Mr. Jacques. Thank you, Mr. Metagakis. And now we go to Ms. Salma Zaid for 6 minutes, please.
Thank you, Chair. Thanks to the witnesses for appearing before the committee today. Thank you. My first few questions are for Mr. Chapman. Thank you for coming back again and talking about the issue of the lost Canadians. As you know, there have been many legislative attempts to address the lost Canadians issue. We will both recall S-245, sponsored by Conservative Senator Johan Martin, and in the House by MP Jasraj Singh Hellan. The Conservatives stalled their own bill for 12 meetings over 3 months back in 2023, before using procedural tactics to ensure it never came back for debate in the House. What message did that Conservative obstructionism send to lost Canadians and their families?
Well, that was the second bill I did with Senator Martin. And actually, up until 2 days before the testimony, Senator Martin was all in for amendments. That changed, and it was almost like she got an edict from the party to say no more amendments because she was all in. So it was also interesting that from Mr. Poilievre's office, he sent an email, which I have a copy of, saying that he was all in for S-245. Now, they weren't in for the amendments, which I can't help but look at the sincerity of those amendments. One of them was that there would not be any citizenship ceremonies on Yom Kippur. Well, today's Yom Kippur. So why one, and we can have meetings on this day? I didn't think it was sincere. They brought up the same issues of security, language, and so forth, which brings me to Finley Weinberger. He got a letter saying that he had to put forth a citizenship knowledge test, language, and so forth. Well, Finley just turned 2 years old. So, again, this is not about anything to do with that. The courts have ruled that going back to 1997. This is an issue about fairness, about the courts, about the rule of law and the charter. No party gets a choice here. This is what the law says. And so if we talk about confidence in the system, we have to talk about confidence in the citizenship system and confidence in the court. This is not an immigration issue, period.
Thank you, Mr. Chapman. We just heard some Conservative questions to the other witnesses, focusing on the cost of restoring the citizenship of lost Canadians. They seem to be putting forward an argument that it is too expensive for Canada to recognize the citizenship of people who have been, in many cases, lived here all their lives, contributed to Canada, paid their taxes, and always thought of themselves as Canadians. So do you think it is right to put a cost on being a Canadian?
Is that to me?
Yes.
Oh, absolutely not. Canada, when you take a citizenship ceremony, it's a two-way street. They say, you have an obligation as a citizen, but likewise, a country has an obligation to their citizens. And one of the obligations that all governments around the world are supposed to adhere to is to protect the rights of their citizens and to make life better for their citizens. It's not a cost function. The court, in this case, in Bjorkquist, did not say, protect these people up to a certain price tag. They said, this is a right, done. There should be no issues on the money. And actually, when it comes to the money, it's interesting. Bill C-37, which was a conservative bill, it's almost as though this side and this side switched places, because years ago, 20 years ago, when I was sitting in the witness stand, the Liberals were saying the same thing about security background and knowledge. I mean, it was exactly the opposite, except different parties. So the Conservatives, and I have the interim leader on camera saying, it's an irrelevant issue. So what if there are 200,000? We need people. This is not an immigration issue. It's a citizenship issue. So if you're going to start taking away rights of citizens, what do? Do we take away the entire citizenship of everybody in Victoria? No. It's a citizenship issue. They have rights, and they are quite within their powers to expect the government to protect their rights.
Definitely it is about rights. And can you explain a bit more that why would you say that this bill is about restoring citizenship and it is not about immigration?
Well, that's what the courts ruled. There was nothing about immigration in that court case. And there was nothing about immigration in the Benner versus Canada case. This is to restore citizenship. They declared the law was unconstitutional, period. So how do you want to go forward? You want to make the charter or the Citizenship Act charter compliant and conform with the Constitution of Canada or not? So this is about citizenship. I know because
15 seconds.
I've been 47 years, I said, trying to get my citizenship restored, and I've been down this path since I was about 10 years old, listening to Canadians over and over and over again say I had to have, and by the way, all parties, everybody's guilty here, all parties saying I had to have a criminal background check and so forth to get into Canada, to get into my own country. It's an insult.
Thank you, Mr. Chapman. Thank you, Ms. Zaid. Monsieur Brunet-Duceppe, c'est à vous, 6 minutes.
Merci,
Thank you, Madam Chair. Thank you to all the witnesses for being here. I first have a question for the Parliamentary Budget Officer. Earlier, I asked the Minister how many people C3 could potentially affect and create new citizenship. She was unable to give me a figure, but your department is able to come up with a figure. So shouldn't a minister who introduced the bill know the figure? What's the difference between how IRCC and your department does this work, this calculation? The figure we have is an estimate, of course. When we look at the estimates on the Canadian diaspora, it might be 300,000 or it could go up to 4 million. So what we did is we looked at a Statistics Canada study. It's a demographic study from 2018, and it rebuilds from 1921 to 2016 the Canadian diaspora divided into 3 groups, including citizens by descent. So we took that study, and with some assumptions, we've gotten to our figure. And you were able to estimate the cost of $20.8 million. How did you get to that figure? 20.8 million. We looked at the 4 groups that would have been affected by C-71 at the time, and what we did is we asked certain departments that how much it had cost to deal with grants of citizenship. We also communicated with GAC to get some figures on consular services for regular and extraordinary cases, like, for example, war. And then we just multiplied all of those costs, and we arrived at the figure of 20.8 million. And we know that Prime Minister Carney asked all of his ministers to make cuts. Do you think that IRCC has enough resources currently to process everything, all the applications under C3 if it does pass? Do you think that right now they have sufficient resources at IRCC to process all of the potential applications? We haven't assessed the department's budget. It's difficult for us to say if they have enough resources or not. Okay, thanks. Did you get any assessments from IRCC about the number of people that would be affected, about the cost? Did you ask any questions? Did you get answers? In October 2024, we sent a question to the department to find out if they had any estimates on the number of people who would be affected by C-71, and the answer was no, we don't have any estimates. They also gave us some suggestions about how to come up with an estimate. So they didn't have any figures. They told you. Not to our knowledge, they didn't have any estimate, no. Earlier on, I reminded the minister how the Immigration Act works, because she said the 1,095 days, that is fine, was based on the same 1,095 days requirement for permanent residency, but she had forgotten that those days have to occur within 5 years rather. Do you have any figures? I imagine you don't, but I'm just wondering, would you be able to calculate the same figures if you looked at that requirement, the 1,095 days over 5 years? For the moment, there's no specific hypothesis for the 1,095 days. We have a hypothesis that reduces the number of Canadians potentially affected, because theoretically, more people may be affected by the measure. And when it comes to the question from immigration, I imagine it's just a question of data. It's difficult to obtain that data. I can't really provide an answer. Mr. Chapman, do you think that there are cases of lost citizens that would not be covered by C3?
And there are. It does not correct all
15 seconds.
It does not correct all the categories, but it comes very, very close. And you know what? There are always going to be problems.
Thank you, Mr. Chapman. Thank you. Merci, Monsieur Brunel-Duceppe.
Thank you, Mr. Brunel-Duceppe.
We are now on to our second round. Mr. Ma for 5 minutes.
Thank you, Madam Chair. My following questions are for Dr. Bonner. You published a study in May of this year entitled Repairing the Fray, where you investigated Canada's immigration policy. On page 18, you wrote that nearly 60% of Canadians of all backgrounds now claim that newcomers do not share Canadian values and that they fail to integrate themselves with Canadian society. Do you feel that this lack of integration could be addressed in Bill C3, substantial connection test, by adding, firstly, a language proficiency test in either English or French, and secondly, a citizenship test requirement?
The answer is yes and no. I mean, in principle, I think that something needs to be done about this, the problem that that you cite there, and those aren't numbers that I made up. Those are reputable polling firms which you can find in the footnotes to my study, and I would be very surprised if that number had not, in fact, risen. Those sorts of safeguards need to, and not only cultural but also economic integration, those need to be built into the immigration system in general, not just into one bill. And it is also a philosophy that the country as a whole ought to adopt. And if you look in the context of that statistic that you cite there, the context is a reaction to the context is the idea that there is nothing into which to integrate, or like the theory that there is a kind of cultural void in Canada that therefore that doesn't require any kind of effort to acculturate anyone, or that there are no particular values, no particular principles. You know, that was a refrain that was often heard over the past decade, and I think the Canadians know that isn't true. So yes, we should do that, but that must be that must be a philosophy adopted into the immigration system, our attitude to citizenship, our attitude to the country as a whole.
Thank you. And on that same page, you wrote that more and more newcomers are leaving, having formed no permanent connections to the country and moving on to other economic opportunities abroad. Further, you cited that 25% of all immigrants will leave within 25 years, and a little over a third of them will do so within the first 5 years. You place special emphasis in noting that among those who leave, 48% are economic immigrants. Do you feel that the lack of connection to Canada could be addressed through Bill C-3 substantial connection test by adding a longer residency requirement?
Yes, I think in general that should be done for citizenship policy. The economic statistic that the economic immigration statistic that you mentioned there, that goes back, if I remember correctly, to a study, not one that I did, but one that I referenced called The Leaky Bucket, very memorable title. I interpret that to be actually quite an alarming fact that economic immigrants are chosen because they wish to invest here, they have offers of jobs already, and that the skills and so forth that they bring, or the level of education and skills training brought to the country, are those that we need, that they are vital to us. If they are leaving, I think that bespeaks a very serious problem that we need to address, that we need to look into. Part of the problem is undoubtedly connected with that feeling of scarcity, of sort of strain on infrastructure and so forth that we have all felt, especially people of my generation, over recent years. And I think certainly more could be done to retain the highly skilled and well-trained people that wish to come here and integrate, and the fact that we don't is a problem. Again, something about that, some sort of solution needs to be found. And yes, it may be wise to build it into Bill C-3.
Thank you, Mr. Bonner. Thank you, Mr. Ma. Thank you.
General.
Our next questioner is Mr. Fredgiscatos for 5 minutes.
Mr. Chapman, you made the point in this meeting and in your testimony that the issue before us is not one of immigration, it's about citizenship. Thank you for making that clear. I think it reminds us why we're here with respect to Bill C-3. Earlier today, we heard a lot about chain migration. I had to check, I felt like I was in another country listening to a particular president who loves that phrase, and you can, I think, pick up on what I'm talking about there. But without digressing, I want you to go back and talk about this from a fairness perspective, and also looking at C-3 as putting forward a measure or set of measures that would ensure consistency in our citizenship law.
The citizenship law has never been terribly consistent, and IRCC is consistently inconsistent. So it's been a real problem. Again, there are at least 15 categories of lost Canadians. Most have been fixed. So I've been fighting it all my life. I mean, I was 6 years old when Canada took away my citizenship, and I've never heard any argument other than what's coming out of here, that I'm trying to immigrate back to my own country and so forth, and I always found that very insulting. I was born a Canadian citizen, and these people have a constitutional right of citizenship, not a constitutional right to immigrate. Anybody can immigrate, and if we're talking about chain immigration, well, there's one way that anybody can come to Canada and get in. Just have your baby born on Canadian soil. That's jus soli. So anybody who's not a Canadian can arrive and have a baby, and that's it. You're in. So fair has to be equal on both sides. And so if we're going to go with 1,095 days for immigrants, we have to go for 1,095 days for lost Canadians. Here's the problem with the consecutive. I was an airline pilot. I left the country for 2 weeks every month. I could never in 40 years have gotten the consecutive. That's out. Naturalized Canadians don't have to do consecutive, and on top of that, they have 2 other ways they can prove their substantial connection. That is not true for lost Canadians. And so we just have to make it equal. As far as being consecutive, Canadians, and part of this Bjorkquist case was Section 6 of the Charter, mobility rights. Well, one of the members of this committee, I think, was married to an American and spent the COVID year down in Oklahoma. She would have lost her citizenship over that years ago.
Okay, Mr. Chapman, I'm going to, I only have about a minute and a half left. Can I ask you about what we've heard here at the committee about the number of those that would potentially become citizens, but can you add some nuance to that? Because,
sure.
And I respect the work of the parliamentary budget officer, but there's been a number here of 100,000 plus that is a number, but without a lot of context that I'm not expecting from the PBO. It's not their job to provide that, but you have that particular context, I think, because you've written on this widely, you've appeared before previous committees in previous iterations of studies of C-71, for example, and other bills that have been before us in previous years. Talk about the nuance of that, because I think committee members might be left with an impression that the door is being opened here to 100,000 plus people arriving into the country, when I think that's certainly not the case.
Of course, if it was, again, the courts didn't put a number on it. But if one of the greatest cases there would be the Advocate General for Scotland versus Romaine. They did the same thing basically as S3. But here's the point. C-37 opened the door to 1 million people, maybe 2 million. And in the 16 years since that became effective, 20,000 people showed up at Canada's door to say, I want to be Canadian. A lot of those people lived in Canada. So we're talking maybe tens of thousands of Mennonites who already live here will now get their citizenship. They're probably part of that 115,000. So it's not just a matter of how many people are there. It's how many people are going to show up, and they're not going to be make no assumption that these are people who are going to be on social services. These are people contributing members of society. And so, and they already are. They just want to be legitimized.
Many of whom who are already here.
Already here. Count at 115,000, 1 to 2%.
Thank you, Mr. Fredescatos. And now we have Monsieur Brunel-Duceppe, 2 minutes.
Mr. Brunel-Duceppe, 2.5 minutes. Thank you, Madam Chair. As lawmakers, we're trying to get as much information as possible. That's why you're here with us. I'd like to come back to the number of people affected. When I heard 115,000, I can imagine it was complicated to create a framework of analysis to come up with that figure. Were there other scenarios where fewer people were affected or more people were affected? How did you land on the 115,000? Can you tell us if it might be much higher or much lower? As I said earlier, our analysis is mainly based on a StatsCan study. And in the study, there are 3 levels of estimates. We chose the middle one. There's one that is lower. We could have the figure, and then the other one is higher. It's 1.5 times the figure. So in that case, the Canadian diaspora who would be citizens by descent would be around 2 million. And then in that case, 1 million people would be Canadian citizens by descent, or it could go up to 3.4 million. So we could look at those figures that we came to and either halve them or multiply them by 50%. So that's the range that we were looking at. Now, the next question is, who is going to apply? So we also came up with estimates about that. We think our estimate is reasonable. It could be higher, it could be lower. And I can imagine that a lot of those people might come from the U.S. People from the U.S. may be more likely to apply. It's possible. You didn't do a breakdown per country? No. We could refine it, but we came up with an aggregate number. Do you think it's reasonable for the minister to arrive without being able to tell us how many people would be affected? It is not up to us to say. Thank you, Mr. Jacques. Thank you, Mr. Brunel-Duceppe.
If it's okay, maybe I'll give 2 minutes each to each of the Liberals, the Conservatives, and the Bloc. Is that okay? 2 minutes. Okay, we are going to start with Mr. Davies.
Thank you, Madam Chair. Mr. Bonner, I was struck and interested in your comments at the beginning about the value of Canadian citizenship and what it means to be a Canadian citizen, and your commentary on the evolution of this sort of post-national philosophy that obviously has not gained the traction that it was at the time. But I'm curious as to what you think of the provisions in, or the lack of provisions in this bill that, for example, no language check, no test of citizenship, no knowledge, no test of self-sustainability once you arrive in Canada. And as the minister said, you can have citizenship by cottages, by literally just staying in the country for 1,095 non-consecutive days. What do you think that overall philosophy and the approach in this bill means to you in relation to the value of Canadian citizenship?
Thank you. Well, as I said in my opening remarks, I don't think that there's a question as to whether or not there are some people who should have their citizenship restored to them. I don't know if anybody's actually debating that or suggesting that there's some reason not to do that. My concern is, again, citizenship should count for more in general, and that the higher priority of the government and of the Canadian public should be to restore confidence to a citizenship policy and an immigration policy that are very often
15 seconds
together, rather than sort of minor tinkering here and there. And if Bill C3 is got wrong and it's open to abuse and this is seen in public, it will only add to the problem.
Thank you, Mr. Davies. Our next questioner will be Ms. Zaid. 2 minutes.
Thank you, Chair. Mr. Chapman, my question is that we have been hearing a lot about the term lost Canadians. So can you please explain more about what that really means and some of the real people who have found themselves in that category of lost Canadians?
Very quickly want to make and clarify one comment here. You don't get citizenship for being here for 1,095 days. If you're 1,095 days here and you're a Canadian, that means you have the right to confer citizenship to your child. You just don't get to show up, live, and get it. That's an immigrant. Okay, lost Canadians. I made up the name years ago, and governments don't tend to say, look, if you go look under that rock over there, you're going to discover some dirt on our country. So all I knew at the time was I wasn't Canadian. And then the internet came out, I put it out there, and people started contacting me. We discovered lots and lots of ways that Canada had been stripping people of their citizenship. For example, here's one that's coming. When did citizenship begin? Well, the government says 1947, but it didn't. It began with Confederation. So there are all kinds of ways we've discovered. So we've just been categorically calling people like that lost Canadians. That's how it came about.
My last question is that, as we all know, the Ontario Superior Court of Justice has ruled on this issue and has allowed for an extension until November 20th for a legislative solution. So could you speak to why it is important that this bill be passed as soon as possible?
Because it just opens the floodgates after November 20th. But it is interesting to note that prior to Bill C-37, there was no generational limit on citizenship.
15 seconds.
It had been that way for 146 years, I believe, and Canada was opening the door for immigration. So we've already had unlimited generational citizenship. Bill C-3 does not do that. It just corrects an unconstitutional part.
Thank you, Mr. Chapman. Thank you, Ms. Zaid. And then, pour terminer, Monsieur Brunel-Duceppe, 2 minutes.
Merci, Madame.
Thank you, Madam Chair. Thank you to all the witnesses. We had very different opinions and a lot of very relevant information to help us make an informed choice. Mr. Parliamentary Budget Officer, you said you calculated the cost of $20.8 million based on research about the 1,095 days. Earlier, I mentioned that before 2019, exits from Canada were not taken into account. Same for flights. Did you take that into account? And if you didn't, do you think it would be even more worth your time to really verify that 1,095 days? No, we didn't take that into account. Very few details were provided before. It's an excellent question. It's something that we should definitely consider, but I can't give an answer. Okay, is it something that you could take into account in an analysis? It's the kind of thing that we don't always keep in mind when we have many files to juggle. Yes, if there's a request made from the committee, we'd be happy to provide that estimate. We are here to support you. You are our clients.
Okay, so we're making that request, Mr. Jacques, in 10 seconds. Ça va?
Merci. Je vous laisse le reste de mon temps, Monsieur Chapman.
Thank you. I would like to leave Mr. Chapman the rest of my time to make final comment.
I tried.
Merci, Monsieur Brunel-Duceppe.
Thank you, Mr. Brunel-Duceppe.
To all of you for your excellent interventions and for all of your contributions to this very important legislation. Our next meeting will be Tuesday, October 7, for the clause-by-clause study of Bill C3. Any amendments must be submitted to the clerk by noon tomorrow, Friday, October 3rd. Since it is the end of our meeting time, this meeting is adjourned.